Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Thank you for joining us on this month's webinar, which is Managing Leaves, Medical, LTD, and Return to Work Strategies. Not surprising, this is one of our most popular topics that we present on and something we do every single day. For those of you who are new to the webinars, welcome. And just to give a little background, we're a virtual Canadian law firm specializing in employment, contracts, law, and litigation. You can put questions into the chat during the webinar, please, and we will get to them after the presentation. I think that'll just make things run smoothly. And just administratively as well, you can download the slides under the Handouts tab. And for more resources, you can check us out on springlaw.ca, where you'll find our award-winning blogs, a link to subscribe to our monthly newsletter, and info on our subscription programs for all employers. So, yeah, so next slide if possible. So I just want to introduce me and Jeff as well briefly. As you now know, my name's Phil. My full name's Filip Szadurski, but everyone just calls me Phil because the other one's hard to say. And I'm the litigation knowledge portfolio lead here at the firm, which simply means that I keep the firm up to date on litigation updates in the world, case law updates, build a precedent database, and generally litigate a lot. My colleague Jeff is the AI portfolio lead, so he does an awesome job of keeping us up to date on all the technology changes and shifts that happen very regularly in our field, and most notably right now, the current AI trajectory that in the legal world. And he's also a litigator and solicitor and does a lot of complex business disputes as well. Next slide. Thank you. Just a quick acknowledgement that we acknowledge that the land on which we operate is traditional territory of the Anishinaabe, Haudenosaunee, and Huron-Wendat and the Mississaugas of the Credit First Nation, who have stewarded these lands for generations. We recognize that Indigenous people lived and thrived here long before the arrival of settlers, and we acknowledge that lasting impacts of colonialism. As part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs. We are grateful to live and work on this land. So, just moving on to the next slide, we will be getting into content very shortly. And there is, just before we do that, a quick legal disclaimer. You know that we love this little infographic, but the actual disclaimer that we put out there is just very brief. We are lawyers nonetheless, that this content is not legal advice. In short, it does not create a solicitor and client relationship, and you have to apply your own judgment. And very importantly, law changes every day, especially in employment law. So everything we present on today is only as current as today, so legal advice should be sought for any active and current issues. All right, so with that, I will hand it off to Jeff to give a presentation roadmap of what we're going to be doing today.
Thanks, Phil. And so this slide sums it up. We're going to do an introduction. We're going to talk about the legal framework in which we operate with respect to these issues, including human rights issues, which breaks down to the duty to accommodate, the obligations and limits within that duty to accommodate, WSIB and benefits, and short-term disability and long-term disability, which are quite complex issues. So let's dive right into it. Next slide, please. There's our one more. So navigating illness and disability in the workplace involves managing both legal obligations and business needs, and it's about balancing those as much as possible. So for employers, you need to navigate common law principles, human rights legislation, and specific workplace agreements. In most cases, employment agreements or collective bargaining agreements are the specific agreements, but there are also ancillary documents that will affect the analysis. And failure to address these areas adequately is a great way to expose yourself to legal and consequently financial risks. So this presentation is aimed at providing a roadmap for employers to manage these issues effectively and to mitigate any potential legal or financial risk. The focus of the presentation is going to be on the provincial jurisdiction of Ontario. Both Phil and I practice in most of the other provinces and in the federal jurisdiction as well, as do all the lawyers at Spring. Next slide, please. And I'll turn this back over to Phil.
Yeah, so I'm just going to quickly go over the legal framework that we are going to be presenting on today. It's important to note right out of the gate the Ontario Human Rights Code, and I'm sure most of you have heard about it. The Ontario Human Rights Code protects against discrimination and harassment based in certain grounds. Those grounds include disability, which we're mostly going to be talking about today, but also include family status and other grounds like religion and association. And the key is that the Ontario Human Rights Code is ever present, whether you're complying with minimum standards or not complying with minimum standards, whether you're in a battle for common law entitlements. The Human Rights Code is ever present, and the facts of one's case and circumstances are crucially important, especially when you're talking about medical leaves and return to work plans, because the Human Rights Code will always be present on those facts. The Employment Standards Act in Ontario is the minimum standards legislation. It includes various types of protected leaves and minimum wage, overtime rules, all of that sort of stuff, which is somewhat wholly separate from the Ontario Human Rights Code, but very related, because in any one case, they'll both be active and need assessment on any facts at play. And as Jeff was saying, in the federal jurisdiction, the Canada Labour Code is the minimum standards, and various employment standards run through other provinces as well, but are quite similar. The main differences between the Canada Labour Code and the provinces. And then there's also common law obligations, which go above and beyond minimum standards. And at the end of the presentation, we're going to briefly talk about WSIB regulations and short-term disability and long-term disability, because each one of these areas requires specific compliance in relation to employees who are going through any sort of leave of any kind related to disability, illness, or such. So next slide. And we're off to Jeff. Or is this my slide? I think this is my slide.
That's yours.
Yeah, sorry about that. Common law employers are allowed to terminate at any time without cause. So this is an important distinction, because we talked earlier about discrimination and things that you're not allowed to do, and we'll be talking a lot about it today. But technically, in Canada, you are allowed to terminate an employee generally at any time you want without cause, as long as you pay them appropriate notice. And what that notice is depends if you have a contract or not. But the big caveat is that you cannot terminate for discriminatory reasons. And this often catches employers off guard, because the discriminatory reasons can be by accident, can be without knowing it, and can be quite, in some minds, minimal on the facts, but discrimination can still occur. So reasonable notice is required upon termination, unless frustration of contract applies. And courts do consider disability when determining the notice periods themselves when an employee is terminated. Employers also must exhaust the duty to accommodate before terminating, which will be a big point of discussion today. So thanks, everyone. And now it's over to Jeff.
Thanks, Phil. So I want to disclose I have a spinal cord injury and I use a wheelchair. Subsequently, I've got a very strong personal interest in the area of human rights, disability management, return to work, things like that. I dislike enormously when the human rights regime is misapplied or abused, and I act on behalf of management and employers regularly in circumstances where the human rights scheme writ large is at issue, and is being misapplied in often cases. So next slide, please. Having said that, the definition of disability is quite broad, and the Human Rights Code defines disability to cover a wide range of conditions, including episodic and invisible impairments. And that's where things get really tricky. When I show up to an event, I'm sitting in a wheelchair, it's obvious what some of my limitations may be. With invisible disabilities, it's much more difficult and often requires what can be an awkward conversation at times. But those conversations ensure inclusivity and equal treatment in the workplace. And if you're unsure or uncertain whether your internal policies align with the definitions in the Human Rights Code or other legislation, give us a call, and we'll provide a detailed legal review and analysis. Next slide, please. So essentially, if someone claims a disability as an employee, they need to provide medical information showing how their condition affects their work. So employers are somewhat limited in that they can only request details relevant to the accommodation process. You can't ask what the diagnosis is, right? So if we use me as an example, I can't climb stairs. You don't need to know that I have a spinal cord injury. All I need to do is tell you I can't climb stairs. So, and you can ask, can you do these tasks? If not, can we provide accommodations to help you do these tasks? And that's really the crux of these conversations that I'm talking about. Again, we can assist you in creating standardized forms, processes for evaluating requests, all with the aim of ensuring consistency and compliance and not breaching any of the legal obligations that you have. Next slide, please. So this is an interesting part of the Human Rights Code and the scheme, again, where there's a duty to inquire. So the duty to inquire arises whenever employees notice signs of potential disability. So this can be things like frequent absences, declining performance, which often are reacted to with discipline. And then, a month or two later, employers get surprised with a breach of human rights complaint. These proactive conversations that I've talked about a moment ago can prevent those legal claims and foster trust with the employees. Again, we offer manager training to help recognize the situations and handle them appropriately. Because, look, to be frank and honest with you, they're very difficult to navigate sometimes. We can help you figure that navigation out. Next slide, please. And this is turning back over to Phil.
Thanks, Jeff. That was all great stuff. And we're going to dive into what the actual duty to accommodate is, because it is quite misunderstood. And we can jump to the next slide. And this is a quote from one of the leading cases out of the Supreme Court of Canada, which we don't do quotes a lot, but it's an important one. And it just says that the duty to accommodate requires that a service provider demonstrate that it could not have done anything else reasonable or practical to avoid the negative impact on the individual. This duty applies to all aspects of the relationship with the employee, and it must be done with the goal of ensuring equitable access. Well, what does that mean, right? And the shortest way to explain it, and I explain it to my employer clients this way, is that the duty to accommodate is a very high bar. It's not an unlimited bar. You don't have to do anything and everything possible, but it depends on who you are as an employer. So I generally advise that the larger you are as an employer, the larger funding that you have, the higher the burden for you to accommodate an individual, right? You don't often have to create a brand new job, but if you are Amazon, you basically have to do absolutely anything to the point of undue hardship, including putting them in new positions that may better fit their restrictions, short of creating a brand new job. But when the employment size is that big, tribunal is going to basically tell you that you have to do anything. Versus on the other end of the continuum, a grocery store with one employee, that a valid disability could really affect the business as a whole if it was accommodated. And then there's an entire continuum within there that requires assessment on an individual case basis on whether the duty to accommodate would be triggered in those circumstances and what an accommodation would look like. Because in the latter example, that business, if they were to accommodate even a simple accommodation, sometimes it could cause the business to go under. So that's just a practical kind of approach. So next slide. So the duty to accommodate does have two distinct factors. They're of course related, as all of them are, but there is the procedural and the substantive duty. So the procedural duty is to conduct a thorough, individualized assessment of the employee's needs. So this starts as soon as there's either a perceived, as Jeff talked about, disability or an accommodation requested by the employee. As soon as one of those triggers, then the employer is required to do a thorough assessment and assess the individual's needs. And then the substantive duty is to implement the meaningful accommodations to the point of undue hardship. These are interdependent aspects, and failure in either one can constitute a breach of the Human Rights Code via discrimination. So it's very important that they're, from the outset, it is taken with white gloves and assessed appropriately, because the ultimate goal is just to make sure that this individual who's going through living with a disability can work, right? That's what these protections are for. So at the end of the day, when someone brings forward an accommodation request or an employer perceives a potential need, then the duty is triggered to just answer the simple question, is it at all possible to help this individual keep working within our means as an employer? Next slide, please. So a key part of the procedural duty under the Human Rights Code requires active good faith and participation from both the employer and the employee. So this is a lot of the time there's like this urban myth that as soon as the Human Rights Code is triggered, that employers have no ability to have any rights in the circumstances at all, which is untrue, but it can seem that way sometimes, right? The employer, as already mentioned, has all of these responsibilities and assess needs and explore options, but the employee must provide relevant information, engage in discussions, and cooperate with reasonable accommodations. They can't hide information. They can't refuse to ask questions that are reasonable questions, right? They can't say no to a reasonable accommodation. The accommodation does not need to be perfect. It just needs to be reasonable. And the threshold of reasonable isn't as high of a bar as the actual accommodation process itself. So it's not impossible, but it can seem that way sometimes, and it's definitely shared as an impossible task out in the media and in the annals of employer side discussions. And I'd just like to repeat this many times throughout a presentation, because it's something that slips on employers a lot, and employers get messed up a lot on. And Jeff has already mentioned it. Employer is not entitled to a diagnosis, subject to very few circumstances, which we will not get into today. Diagnoses are just off the table, and we see it all the time. So open communications are key, and they ensure that needs are understood, effective, reasonable solutions are identified, and like it was mentioned, failure to collaborate may breach the procedural duty by both, right? Employee or employer, okay? So thank you so much, and on to the next, and Jeff will take over on the limits of the duty to accommodate.
Thanks, Phil. And just to reiterate, there's procedural, substantive, and duty to collaborate. So how you do it, what you do, and have a conversation. That's what it breaks down to. It's simplified as much as possible. So the duty to accommodate does have limits, particularly in the substantive area. Employees have a right to accommodations, but they can't demand a specific solution if another reasonable option effectively meets their needs. So it's not tailor fit. It's a request for an accommodation, and then it's a negotiation between the employer and the employee, ideally, right? It's honest communication and trying to figure this out together. That's the duty to collaborate. So under the Human Rights Code, employers have to provide accommodations that enable the employee to perform their job. That's the ultimate goal. Phil mentioned that a moment ago. And they have to do this, they have to provide the accommodations to the point of undue hardship, but you're not required, again, to implement the preferred or ideal accommodations. So reasonable accommodation, what does that mean? It means that employers can propose alternative solutions, providing they effectively address the barrier. You have to do that carefully, and you have to do it, respectfully and in the spirit of collaboration. But you can suggest other options. And frankly, look, I'm a person with a disability. There's things that I haven't thought of, right? So if my employer makes a suggestion and it's a good faith suggestion, you got to consider it. I think that's my advice to employees who have disabilities anyway. An example of this is offering flexible hours instead of remote work. If that meets the needs of an employee with a disability. I'm a big fan of remote work. I think it works, but it's a case-by-case assessment. The collaborative process, again, communication is the key, right? Employers should explain to the employee why a simpler accommodation is sufficient, and then engage in dialogue, which does two things. It satisfies the legal obligation and it builds trust with the employees. Please document, right? Keep records of all the discussions, all of the options that are offered and considered. It demonstrates a good faith approach, and it protects down the road against potential claims of insufficient accommodation. Documenting can be as simple as sending an email to a colleague, right? Senior management communicating internally, hey, we offered this accommodation. Here's why I think it'll work. Document the conversation that happened after that, but document the process. It helps Phil and I, or whatever lawyer is helping you out with potential problems down the road. Next slide, please. So again, the limits here. The duty to accommodate is not unlimited. It has clear limits. They're outlined in the Human Rights Code and in the case law. Again, employers have to make meaningful efforts to accommodate, but only to the point of undue hardship. And undue hardship breaks down into broadly three categories. Cost is a consideration, but they have to be so significant that they jeopardize the business's ability to operate. And again, so that's what Phil was talking about the range. This is a different test for small businesses and massive enterprises. Courts will consider available subsidies or other supports before accepting cost as a defense. So if there's a subsidy to build a ramp, and you claim that you can't afford it, if you didn't investigate the potential subsidies, your defense gets a lot weaker. Health and safety is the next sort of button, where risks posed by accommodation must be substantial and evidence-based. I'll give you an example. So, the textured features that are at intersections often, where someone who's using a wayfinding device like a white cane feels the texture, they know there's an intersection, it saves their life, right? Those same little bumps are very difficult for me to navigate because my wheelchair has tiny little wheels on the front, and it's like roller blades or roller skates. You hit a bump, you stop dead. So the same accommodation, these textured features, are great for people who are blind or low vision, but they're not great for people who have wheelchairs. So I'm giving you this example just to flag that there can be safety risks even with perfectly good accommodations from one group to another. So the health and safety issue has to be considered. External funding, and this loops back to the cost. So employers are expected to explore external funding opportunities, grants, tax benefits, things like that, all to mitigate the expense of an accommodation if one exists. Again, document all of these efforts, document the research you've done, document if you get expert guidance. So if you can effectively demonstrate compliance and defend against potential future claims. The approach is essentially ensuring fair balance between employee rights and operational feasibility. Next slide, please. And this is where we're getting into the more invisible disabilities. Like I said, I show up, I'm in a wheelchair, it's obvious. Someone who has a mental health issue, it can be very difficult to wrap your arms around what it means. And again, with the limitation of not being able to ask for a diagnosis, it can be very, very difficult. But mental health is a critical part of accommodation under the Human Rights Code. Things like flexible scheduling, workload adjustments, providing mental health resources are all ways to help address these issues. And promoting workplace awareness and reducing stigma are proactive steps that you can take. Building that trust, especially with more invisible disabilities, can be a crucial way to avoid potential problems. Legal risks arise if terminations are related to mental health and they fail to meet accommodation obligations. So to go back to the example from previously, you've got an employee who is coming in late three times in a row and you don't know what the issue is. Instead of disciplining them, we encourage you to ask why. Why are you being late? Is there something I can do to help you not be late, right? Is there an accommodation you require? And that's a way to ask, right? It's as simple as that. Is there an accommodation you need to help you do your job? And if they say no, then it doesn't end the obligation. You have a continuing obligation to inquire, but it's a very good fact if there's a future claim of refusal to accommodate. Next step, please. Next slide. So just to summarize, duty to accommodate that we've just talked about, you've got a procedural duty, you've got a substantive duty. There are limits to the accommodation, and the process is supposed to be collaborative. Ideally, it's a conversation. It's both sides, the employee and the employer, who are working to get that person working efficiently and effectively and keep the business running. Okay. Back over to Phil for WSIB.
Thanks, Jeff. That was awesome. We're going to chat about WSIB disability benefits, and Jeff will chat about short-term and long-term disability, but we're only going to touch on it briefly, sort of in an iceberg approach, mainly because we do a lot of this work on the advising side, employers on compliance. We don't do a ton of the litigation work on this because it is very akin to personal injury litigation, especially with WSIB and short-term and long-term disability. So we're speaking to this from more of a compliance angle and the type of work that we do in this area predominantly. So WSIB, if you don't know, it offers benefits to a worker who was injured on the job, right? And that could include a psychological injury and a physical injury. If it's psychological, often WSIB will try to deny it, but there are appeal routes for the employee. They just take a really long time. So it's very important with WSIB to cooperate in return to work efforts, because every employee who gets hurt on the job will likely be assigned a caseworker, and their goal is to get the individual back to work, because honestly, the WSIB is very interested in getting someone back to work because they don't want to keep paying benefits long term. So it's very important to avoid premature termination tied to the injury. There's actually a 1-year restriction on terminating the employee after returning from an injury. Of course, this is not ultimate, but it's very strict. So you definitely want advice from an employment lawyer if a termination post-injury is something that needs to be addressed. As Jeff has said many times, document, right? accommodation efforts. You wouldn't be surprised how many employers do not document, either due to just being overwhelmed or not wanting to address conflict. There are many reasons to not document, but it is almost always the downfall of an individual who we advise. And very carefully consider any termination. Again, common theme, the goal is to support the individual in returning to work, and that is whether they are on WSIB or not, and maintaining compliance throughout the WSIB process is important, because just as the Occupational Health and Safety Act, any breaches of the statute can be subject to provincial offenses, which are quite high, and WSIB actually has an automatic director liability section if directors allow WSIB breaches to happen. You don't see a ton of case law out of the provincial offenses on WSIB breaches, but it is possible, so it's most important to avoid any such breaches for sure. Next slide, please. So just related disability benefits before Jeff touches on short-term and long-term disability. Employers must carefully manage disability benefits to avoid liability. And some key considerations are just ensuring coverage during statutory leaves. So remember, at the beginning of the presentation, we talked about the Human Rights Code, Employment Standards Act, and various statutes. The Employment Standards Act has very long statutory protected leaves, and it's important to assess one's insurance plan and how long one can keep an employee on various types of insurance during protected leaves and also non-protected leaves. But to do that, you need to have conversations with your insurer, because every single policy is different and every single policy has limitations to when coverage will apply and will not apply during either a statutory leave or a non-statutory leave. Important distinction. And even on termination, there are distinctions in policies between when certain types of coverage will apply during the statutory portion of the leave versus the non-statutory portion of the leave. And coordinate, this is a good segue into Jeff's section, with the short-term and long-term disability plans, because these types of cases often stretch on for a really long time. Sometimes very common that they go on for years, and it's important to document everything during that time and maintain compliance with your insurance package. So that's it for me on those points, and I'll pass it over to Jeff for the short-term and long-term disability piece.
Thanks, Phil. Great resume there. Can we go to the next slide? We're off the hop here. So short-term disability, long-term disability are semi-overlapping. They're definitely related. The distinctions are generally the scope. Short-term disability is for episodic issues. Long-term disability is for more permanent issues that an employee may have. So we've got some ranges here. The STD typically covers illness lasting from 13 to 26 weeks. And apologies, employment lawyers think in terms of weeks. 13 weeks is 3 months, 26 weeks is 6 months. And the range is quite vast because these ranges are often determined by the policies themselves. Large employers will sometimes, and law firms do this quite often, they'll self-insure for short-term disability. It can be short, 3 months, if the policy that is being carried by the employer starts to cover at 3 months for LTD. If it starts to cover at 6 months for LTD, you're having a different conversation about the cost of self-insuring for STD. But it's often determined by the policy itself. Long-term disability is slightly different in that it covers extended leaves. And usually the amount of coverage is different. If short-term disability can cover 70% of the employee's compensation, and then long-term disability can often change, that percentage can change. It's sometimes after tax, depending, it really depends on the policy. Again, there are legal protections in place that include the overlapping rights conferred by human rights legislation, the ESA or the Canada Labour Code, whichever one is applicable, and then the common law. So judge-made law that goes beyond, that interprets the statutes and interprets the black letter law. Next slide, please. So this is critical in that there is a interplay between STD and LTD that has to do with employment status, it's the fact is that employees on STD and LTD are still considered employed unless clearly terminated. Termination during leave is very risky. We rarely advise it. The first question I usually ask my employer clients is, how much is it costing you? You know, and if it's $100 a month to maintain benefits, or, you know, a couple $100 a month even, is it worth the risk, right? And that's often what we deal with in law is, what is the risk appetite? What is the risk? Is it worth taking that risk to reduce costs in an area? So we're not going to get too deep into it because it's very complicated, but there are two main ways to deal with employees who have been on long-term disability for a long period of time. And it's either through asserting job abandonment, if they're non-responsive to requests for medical documentation, things like that, or simply non-responsive. Or there's a frustration of contract possibility, where if it's a bona fide occupational requirement and the employee simply can't do it, and you've got medical evidence to that effect, then the essential terms of the contract may be frustrated. It's a very, very difficult thing to assert. So it's out there, but we are very careful in how we approach it. If you're running into these circumstances, and we've had a couple of questions already where similar things are, please reach out and we can do a factual analysis of the exact circumstances and try to offer you some help. Okay. Back over to Phil for the key considerations.
Thanks, Jeff. So, long-winded presentation. Well, what does that mean to an employer that's in a situation that is difficult and has an employee that isn't responsive, or has been on disability for a really long time, or who even themselves has stated that they don't think they're ever going to come back, and who has a business to run, right? We gave you a bunch of information, a bunch of strategies, risks, and law talk, but what does that mean at the end of the day when the rubber meets the road? Can I terminate while someone's on a disability or not? And the answer is maybe, right? If it's lawful, usually we advise to wait after a disability, but if it's gone on long enough, as Jeff stated, there are avenues to take, and frustration of contract for a long-term disability is probably the one we see most often, but it's also one that we see trip up employers a lot, because there are distinct requirements when a termination for frustration of contract happens. Specifically in Ontario, let's say you have a 20-year employee, and in the last 2 years they've been on long-term disability, and a doctor finally said it's unlikely that they are ever to return to work. There's magical language, but that it's paraphrased as that, right? In those circumstances, you can terminate for frustration of contract, but because the frustration is due to disability, you still have to pay minimum statutory entitlement, which in those circumstances would be 8 weeks plus 20 weeks of pay, right? So that's still 28 weeks of pay to that individual. And if you miss that pay, and if you terminate for frustration without paying properly in those circumstances, then you could be subject to fines for breaching the ESA or bad faith termination, which is very interrelated in these concepts, which is a common law right, but we won't get into too far because it strays into a whole other conversation of law. So it's important, these circumstances have avenues for employer redress to figure things out and keep the business running, but they just have to be handled with white gloves. And that's because the protection is for the employee. Because at the end of the day, when you terminate an employee for frustration of contract, most likely that individual will never work again, right? So maintaining their benefits, which is the next slide, is a good segue, is incredibly important. Because if a terminate, I'll go for it, but yeah, we'll keep on the next slide. That's fine. But terminating and keeping benefits going is a key aspect, because if a termination happens in the wrong way and for some reason they lose their LTD benefits as a result of that termination, the employer can be on the hook for LTD benefits until that individual turns 65 or the value for the same, right? So there's some big liability points on that. So the key considerations, if we can sum it up, right, at the end of the day, obtain medical documentation to assess return to work potential. Again, no diagnoses, but we use what's called functional abilities forms, and they help employers greatly, and it's a requirement of employee to have a doctor fill one out, right? Consider accommodation obligations before moving to termination. And please, 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 in these circumstances, talk to a qualified employment lawyer, whether it's me or not, because the liability is potentially there, right? So Jeff does want to talk, before we get into questions and answers, a little bit about pre-employment considerations. And we thought this was a nice little addition to the presentation because the Human Rights Code and various other statutes are not just triggered once an employee starts. They trigger even earlier. So Jeff, it's off to you.
Thanks, Bill. And yeah, thank you very much. So the critical issues with pre-employment, where the Human Rights Code may come into play, is in the interview process and in the offer process. So when you're interviewing, it is really important to standardize interview questions, ask everyone the same thing, ensure that you're documenting that the same questions are being asked, and ensure they're relevant, consistent, and focused on job qualifications. Okay, you will be helped by that if you develop clear and detailed job descriptions that outline essential duties and required skills. So up on the slide, you see you have to avoid discriminatory questions. Questions like, do you have a disability? What you can say is, we offer accommodations. If you require accommodations, let us know, right? That's an acceptable question. Where do you have a disability isn't. So they can be quite nuanced. Things like, do you plan to have children soon? Please don't do that. It'll almost guarantee a claim. So there are red flag questions that we can flag to you. We can provide you with a list of questions. We've done this a lot, and we help in this area quite a lot too. So questions about personal characteristics are generally off the table. So your age, disability, family status, things like that. If they are directly related to a bona fide occupational requirement, there may be an exception, but you still have to be very, very cautious. And please, like Phil said, if you have any doubts, err on the side of caution, and please consult a lawyer. Again, if it's us, perfect. If it's not, please still just talk to someone who's gone through this before and has a legal perspective. Please train your managers on what they can and can't ask. Often we see mid-level managers being pulled into interviews because the person being hired is going to be a direct report. They haven't participated in a lot of interviews before, and they can sometimes go offside, and then it's a problem for the employer as well. The use of structured scoring systems is invaluable. So because it lets you evaluate candidates objectively and reduces the risk of unconscious bias, which is a good thing for you, but it's also protective, right? Being able to show a matrix that a rubric that it determines the scores of candidates, demonstrates equality in the evaluation process. And again, documenting that process using these rubrics and lists and questions demonstrates fairness and compliance of every question. I advise my clients almost exclusively to record all the interviews. It's easy now. I always recommend that the recording be disclosed to the applicants because there's no reason to hide it. So record the interviews, stick to the questions, let the applicants know they're being recorded, and all of this is, again, just a safety blanket for trying to future-proof against potential claims down the road. Next slide, please. So I encourage employers to take a holistic approach to all of this, right? Managing illness and disability, interviewing, pre and post interview. And this holistic approach really includes evaluating each case individually, because every case is fact dependent. Document the accommodation efforts, seek timely legal guidance to ensure compliance. Some practical strategies to reduce risk. Early intervention, right? Address the performance issues proactively. If there's a performance issue, assume going in there may be a version of this that you may not understand. Ask why. If an employee is struggling at work, ask them if there's anything you can do to help. Ask them if they need an accommodation. Let them either accept or deny, and you've at least engaged in the duties that you have under the Human Rights Code. Maintain documentation, track the accommodation efforts and discussions, seek legal advice, train your managers. All of these things are critical elements. And one of the areas that we try to focus on is making sure that existing policies both meet the requirements of law in Ontario and provide some level of risk mitigation. So if you've ever faced a human rights complaint in front of the tribunal, the form that you fill out in response to the application has a literal box you either tick or don't tick, and it says, do you have a human rights policy? And if you don't, it's not fatal to your claim, but it's a bad look, right? So if you can tick the box, say, yes, we have a human rights policy, and then you submit it, and it's a good human rights policy, you can point to that as evidence that you take your obligations seriously. So again, it's little things like this that help me do my job down the road if there is a claim against an employer. So those policies are, an accommodation policy, return to work policy, attendance management policy, anti-discrimination and harassment. You have an alternative dispute resolution process. Like, these are all policies that can help both manage the circumstances and manage risk down the road. Phil, do you have anything to add?
No, that's really great. I see the questions piling up, actually, and I think that we have some time to answer all of them potentially if we want to do some rapid fire here. I see one here. What if an employee is given modified schedule, 3 8-hour days, for example, to return from STD and does not comply with the schedule and just says they will not be working those hours? So this question, we have it all the time, and that screams to me an example of an employee not participating in the accommodation process, right? So that is a great time to start papering the lack of cooperation, requesting that a doctor fill out a functional abilities form to clearly stipulate what the restrictions are. And if they refuse to do that, then there may be options down the line for potential discipline and termination, but the first will be to gather more information about what the actual restrictions are as supported by medical documentation. Again, no requirement for a diagnosis to be disclosed, but the employee is required to provide proper information to implement a potential accommodation. There's another one here.
One of the strategies there is also, you should be asking the same healthcare professional for a return to work clearance that gave the no-go for work, right? If one doctor says this employee can't work because of a medical circumstance, that same doctor should be clearing the employee for return. we often see, one doctor says the employee can't work, and they go to a walk-in clinic, and the walk-in clinic says, oh yeah, you're good to go, without really fully understanding these circumstances. And that can be a potential risk from a safety point of view.
Yep, absolutely. That's a great point. Jeff, there's a really good question here. We get this all the time. Employer has an employee that's on leave, but they contribute to the benefits policy, and they're not getting paid while they're on leave. So the employer is wondering, should they maintain the benefits even though the employee is not providing their contribution to the benefits every month because they're on an unpaid leave, right? I always advise to do the same thing. And if the benefit provider allows you to continue the benefits through supplementing the coverage, that would be a safe approach. But I'm also cognizant that Jeff does this work a lot, and I'm happy to hear what Jeff does in these circumstances as well.
Yeah, my practice is the same. It's, the question is, how much is this costing you? And is the risk worth it, right? If it's costing you $500 a year, and the risk is you get a $200,000 statement of claim for discrimination, that's a big risk. So it's always fact dependent, and that's a very common problem. So my advice is maintain for now, have a conversation with the employee, see what's up, and then take it from there.
Absolutely. And next question here. I have never heard of having a human rights policy. What would that include? Or do you mean an accommodation policy? It's a fantastic question. Both the Occupational Health and Safety Act and the Human Rights Code require that certain workplace violence and harassment policies are in place, especially and certain extended requirements are for certain employers of various size as they grow, usually more responsibilities as the employer gets larger. So would be more than happy to discuss this and what those policies look like. Obviously, that would get into legal advice, and providing such policies would be legal advice. So if you have further questions on that, we'd be happy to undertake those questions for you and provide some advice on that.
And generally, we will customize the human rights policy and tailor it to the specific requirements. It can be a paragraph, it can be 10 pages. Right? It's all depending on the nature of the industry. There's a bunch of different factors that go into it, but it can be simple or it can be complicated, and everything in between.
100%. The policy is as good as the employment circumstances in, but it's also only as good as its implementation. Because once you have a policy, and if you don't follow the policy, upon terminations, that's where things get really tricky. So once you're ready and able to put in a policy, which is required, then abiding by that policy is just as important. We have a really interesting
where I encourage a little bit of complication or robustness is in the anti-violence and harassment reporting criteria, where you should have a clear report to this person. Next step is, and that can be for harassment. It can be for domestic violence circumstances that may bleed into the workplace. There are circumstances where having a robust policy is very, very helpful.
So we have a really interesting question from Samia, who is asking about family status accommodation, which is absolutely related to this presentation because it's almost the same test and we get it all the time, and we're happy to answer it. The question is as follows: how to address accommodation needs for 1, reducing hours due to childcare needs for employees that return to work from mat leave and needs this until the child enters school age, and 2, request from an employee asking for permanent work from home accommodation for elder care. So in Ontario, interestingly enough, it's one of the only provinces that requires accommodation for family status for both children and elder, so both vertical types of family status. However, just as we talked about today, those have limits, and there's a robust set of case law on preferences versus accommodations in this area, and this is very factually driven and will depend on what the actual requested accommodation is, and is it a preference versus an accommodation. For example, a individual who cannot get daycare because of their child isn't walking and the local daycare that they prefer only takes them once they're walking, probably don't need to accommodate that. That's only a preference. However, an individual who has a child who requires certain extra care and therefore needs a specialized daycare, right? That won't take them until a year and a half. That accommodation might be required. So it's very fact specific, but in general, preferences are not required to be accommodated, and only true requirements in family status are required to be accommodated. But the big practical aspect too is which hill do we want to die on, right? Because these family status accommodations are often temporary. So how important is this employee to you? How much of a fight do you want to make it? Because even if an employee brings frivolous claims of family status accommodation breaches, they are just as difficult to deal with as claims that are valid. So that's where an employment lawyer proper who does this a lot will advise you on the legal requirements, but also the practicalities of what a file like this looks like. And Jeff, do you have anything to add?
The notion embedded in that question was the employee's request for reduced hours. And so there, again, I don't want to get into direct legal advice, but that triggers an inquiry about whether they need to be paid for only the hours they work or not. And again, it's fact dependent, but it's a consideration when you get requests of that nature.
So we have another question here. Can you please elaborate on workload adjustments? How do you balance this with the perception that it is unfair to other employees if you give them the work? So I think Jeff, in a roundabout way, just kind of answered that. If an accommodation is for less hours, you don't need to pay an employee the same amount of money. Unfortunately, the perceptions of other staff around are not factored into what is required by an employer as much. They are practical realities of a file. However, depending on the size of the employer, if it's a big enough employer, these accommodations aren't often felt enough to cause real upset with staff. But if it's small enough, conversely, the staff usually know that someone has a accommodation need. They don't know the exact nature of it, but they will often know, and any sort of perception of unfairness is often mitigated by that. Not always, and it gets tricky, and that's where advice is important. But it's rarely these circumstances where the person being accommodated is seen as someone who's causing grief to others. And if it is, then that's a conversation to have for sure, and always happy to help on that. How much time do we have? 3 minutes left. Sorry, the questions are flying in, which is great. We love this. This is one of the best parts of this this webinar. And just in case we're going all the way to time while answering questions, we do want to plug next month's webinar, Remote Work, Liability, Home Office Compliance, and Best Practices by our colleagues Jess and Tiffany. You can register now, November 19th, 2025 at 10:30 a.m. Same time, same channel, different people. Just as lovely, depending on if you found us lovely or not. And we will answer a couple more questions here, but we will be over soon, but we'll try to get as many as possible. So next one, we are a fully virtual company, which requires all employees to do computer work full-time. If the employee on leave can only read or use screens for limited time periods, up to 30 minutes, what accommodations would we be required to make? Great question, incredibly fact-specific, and really dependent on if it's supported by documentation. Remember, documentation, functional abilities form from the doctor. And is there a break period that they can use the 30 minutes again, right? Without advising you legally, these would all be important questions. So they can only use it for 30 minutes, but then do they only need a 10-minute break before they use it for 30 minutes again? Because if that's the case and they're a full-time worker, that could be a reasonable accommodation. Is it they can only use it 30 minutes for the whole day and they were a full-time worker before? That's probably an undue hardship depending on the size of the employer, but those are all important questions. What do you think, Jeff?
Yeah, and I mean, there are accommodations like screen readers that allow you to not look at a screen while you're using it. things like that that may help to alleviate some of the symptoms. And, those are viable accommodations. Again, you need to find someone who knows of these things to be able to help you pick and choose what the accommodations might be that are offered might be.
All right. So I think we got into most of the questions. I do want to apologize. We didn't get to all of them. We are running on 30 seconds. I just want to thank everyone for being here. Jeff, I loved presenting with you. That was a lot of fun, and I can't wait to do it again. Again, thank you everyone for coming. We love doing these webinars, one of the favorite part of my job, and I'll let Jeff sign off as well, of course, so I don't take the whole show.
Thanks, everyone. And if you do have other questions and you want to shoot us an email, please feel free to do that.
Absolutely. We look forward to chatting anytime. Have a good day, everyone.
Thank you.
Ciao.